The proceedings was actually truncated by the circumstance I may not wish to delve into now. And afterwards, the matter was adjourned to January 1920. So, in view of the enabling laws, particularly ICJA and Federal High Court Practice Direction, which require the hearing of application, the trial of this case of this nation, day to day, we filed an application for the time within which to hear this application, this matter, to be abridged. So that application was filed and served on the respondent, which is the federal government, and it was adjourned today. It was slated today for hearing. So, and the court had it today, consequently granted the application for a period of time. Though the court took us through its tight schedule, the diary, and obviously it's apparent that the court may not be able to accommodate this date because the Federal High Court is going on vacation on 14th of this month. So, and other engagement, the official engagement is lordship we have. So, adjourn it to 18th of January to hear the application challenging the decision of the court to defend the charge. Because that application is very fundamental in the sense that if it is ruled in our favor, that will bring to an end this charge. And is rooted on strong laws, facts, and argument on laws. Because we of the view, firm view in law, that the 7-count charge, the charge filed against our client, defendant, is not only watery but empty and a worthless paper. So, and we effectively challenge it, and we are of the firm view and believing strongly in law that application will be found meritorious when it is heard. However, you are familiar with the fact that we raised concerns few days ago, me and my colleague raised concerns few days ago through our press statement about his condition in DSS, how he's been subjected to solitary confinement, how his medical experts are not allowed to see him, how the court orders are being flouted with levity by the SSS officials, the authority. So we raised those concerns, and courts made several orders today. First of all, that his place of detention should be changed. 2, that the DSS should allow his medical expert to visit him, and they should comply with orders of the court, and also provide him with good food, and also allow persons of his choice to also visit him, and allow him to practice his faith. Because before now, he hasn't been allowed to practice his faith. So the court made order today to allow him to practice his faith today, and also give him good food. So these are among the fundamental orders court made today, and they are rolling out those orders today. And of course, we are in court. The court said, in the event the detaining authority, the DSS, who has been in the practice of disobeying and violating court orders, flout the order made by the court today, we should come back to court anytime when that is done. So, and we believe strongly that this time around they will comply with court order. So, in the days past, we have had cause to come before this court to file contempt proceedings against the DGSSS following their flagrant disobedience to court orders. And those applications haven't been heard. And we have also incorporated the facts of the manner in which they are flouting these court orders, and itemized the orders of the court which they flouted. So those applications are still before the court will inform the court. The court may order to say, if in the event they proceed to flout any of these orders, the court handed down today, that we should come back to court. And we believe that they will obey court orders made today. We believe strongly, most strongly. So we are coming back on January 18th for the hearing of the application challenging the decision of the court on 18th of January. Thank you so much.
No, we are not too pleased. We walked away with something, but that's not really what we wanted. We wanted to move that application challenging the jurisdiction of the court. That is key to our defense strategy. But that we were not able to move that application today is not pleasing to us. But we can understand the procedural constraints within which the court had to operate today. We went through all that, and it was something quite a little bit out of ordinary. But at least we went home. We're going home with something. Improvement in our client's detention conditions is something that has been critical in our own reckoning, and we got that improvement as court order today. Thank you very much.
The countenance of the judge seems that she didn't understand the importance of these fundamental issues they have been raising. And I keep hearing her telling them file this, file that. And Barrister EJIOFOR has filed almost everything she has talked about. So it's a question of, with all due respect, the courage to do justice to all these applications. If they tell you that somebody is not being allowed access to prayer materials to practice his faith, it's a constitutional matter. You should take it serious. You don't just say, allow him practice his faith. You should allow him have access to the material with which he practices his faith. But when they tell that somebody is confined to a small 2x2 and he doesn't see sunlight, spends almost 24 hours, he's not allowed to mix with anybody, you should take it serious also. And then when they tell you that, from what Barrister EJIOFOR said, that legal processes are brought to the man and you don't allow him to read them, this is a constitutional matter. It's not a favor. Because the Constitution is very clear that an accused must have access to all the facilities that is required to defend himself. And remember here that Nnamdi Kanu is still an accused, has not been convicted. So this is supposed to be a prosecution, not a persecution. And that is why I felt, as a human rights lawyer, I felt a bit disappointed that the seriousness that I had expected to be attached to these issues are not being attached. And these applications are compiled, and they say they have almost about 15 applications. Well, what are we coming here to be doing every day when these issues are not being taken? And I say this because you are toying with somebody's life. You're not talking about his health issues, access to his physique. Is there something that are hiding there? Why not allow his private medical doctor to come and also see him? So these things amounts to disrespect to the Constitution. This is infuriating, this is inciting, this is unfair. And that's why I feel so bad seeing how these things are going on. And I'm saying that, like I said before, it's supposed to be a prosecution, it's not a persecution. And this perception keeps sending message out there that most of these actions are propelled by hate. So if a man cannot be tried transparently with access to all facilities that is required for him to prove his case, then this can turn to become a kangaroo arrangement. Why not just, like I always say, why not send him to Daura and then convict him and try him from there? So this man deserves, transparent trial, deserves access to facilities with which to face his trial. And like I said before, I thought by now, I had the Attorney General saying he has not been convicted, so pardon does not arise. I don't want to say whether he read his law in Jigawa, but let me say this. The Attorney General knows that under Section 174, subsection 1C, that the state has powers to internullate. You discontinue this in seconds. So if you want a political solution, you discontinue it, you grant him bail. It's supposed to be in police custody, not in DSS. And then, like I said before, granting that bail or discontinuing the charge by virtue of Section 174 will open room for genuine platform for negotiations and discussions. These issues must be discussed. If you like, try and jail him 100 times. Those issues, as long as they're not discussed, will keep coming up. Another leader will rise. So this is not the solution, whatever they're trying to do here. So I strongly believe that Justice Nyako, with the experience she has garnered at the bench, that she will do justice to this matter and treat with all seriousness all those fundamental issues. He deserves justice because he's an accused, not yet convicted. And if possible, the president should listen to the voice of wisdom from our elders, from the international community, and take the political solution part. First, he has all the powers. When he say suddenly the president that doesn't respect rule of law is saying that he will not intervene in judicial matter. When he used to arrest people like us and other people, does he respect rule of law? So these things, these comments are unnecessary. What he should do is that under the presidential system, there is provision for the Attorney General to internullate, discontinue this trial, and then go back to the negotiation table and address these issues. This will help to reduce the tension rising in the East. It's very important. Let the president relax the hate with which he's running the country, and things will get better. Thank you.
This is the fifth, if not the fourth, if not the fifth order my Lord is handing over to the SSS, but they continue to flout the order. I think when an institution who ought to respect the court order continue to flout the order of court, it is left for the court to raise his hammer or anger against that institution. If not any other thing, to direct that the director of the SSS should appear before her to clear all these issues. The issue of, yes, I have directed them. Nnamdi Kanu, since 26th of June, has been wearing one particular cloth. I've been visiting Nnamdi Kanu almost every week, on weekly basis, only one cloth, and he has been complaining, sleeping with a pillow. He is still presumed innocent. And we also apply that he should be taken to correctional center, those who are trained on how to keep inmates the prosecution said because of security reasons. So I think this is a high time, because if we are going to file all our facts in conjunction, in addition to the ones we have earlier filed, explaining all these facts, he has given us on the 18th of January 2022 to hear all the pending applications. Then trial will now continue on the 19th and the 20th. So I also want to, we have a lot of stories flying up and down in the social media saying that it's going to be released today. And we know the implication of it, because I don't know who gave them that information. If probably they got information that Nnamdi Kanu was not even brought to court to talk about releasing him on bail today, it may give another impression that may lead to another insecurity. So I'm using this opportunity to encourage our people there in the southeast that they should just allow the normal procedure of the law. His bail application is still in the court file. We are here to move it. Let's see what will happen between 18th and 19th and 20th. May the Lord show us His desire. His desire is very, very tight. And the only problem I am having personally as one of the person in this legal team is her inability to use one of the security agents to set example. There is nothing will stop my Lord. My Lord has, under Section 6 of the 1999 Constitution as amended, you have the right to order that the director of the SSS should appear before you. We have done it on several locations. There was a time the Commandant of Civil Defense failed to comply with an order given by a National Industrial Court judge. The judge then ordered that the Commandant General of Civil Defense should appear. The man sent his deputy or assistant. He said, "No, I want to see the man in person." That is the order. That is the court. So I want to say, well, let's see what will happen on the 18th and 19th and 20th.